This is Chapter 15 lecture video. You should have already read Chapter 15 and have Chapter 15 PowerPoint pulled up and your textbook in front of you. Chapter 15, Self-Incrimination. Let's start on page 455 of the textbook and read about myths and facts about Miranda. Myths. Police are always required to provide Miranda warnings when arresting a suspect. Fact. Miranda warnings are required prior to custodial interrogation, so before police questioning when someone's arrested. Warnings are required at the time of arrest only if the suspect will be interrogated immediately after the arrest. Myth. Miranda warnings must be read verbatim. No. Fact. Although officers are encouraged to use standardized warnings, a suspect's statement will be admissible as long as the person understood the Miranda warnings and did not invoke his or her rights. So as long as they understood it and they didn't say, I don't want to talk. Myth. Once a suspect invokes his or her right to remain silent, so once they say, I don't want to talk, the police cannot initiate questioning again. No, they can. Fact. Questioning must stop when the suspect invokes Miranda, when they say, I don't want to talk. After waiting a few hours, police may re-advise a suspect of his or her rights and resume questioning if the suspect then agrees to talk and does not ask for legal counsel. Myth. The police must give Miranda warnings at traffic stops, detentions, and similar field interviews. No. Fact. Miranda warnings are only required for custodial. They've been arrested and they are getting ready to be interrogated. Or their functional equivalent. They are not needed during traffic stops or other limited detentions where there is no coercive atmosphere. Slide 5, Basics of Self-Incrimination Rights. The privilege is under the Fifth Amendment. No person can be required to make a statement against themselves in a criminal proceeding. Situations that are not covered by the Fifth Amendment, statute of limitations. If the suspect can no longer be charged, then they can't say, I don't want to talk, if they can't be charged with the crime. Immunity. You can't use the statement against a party. Transactional. Can't use the statement or what is discovered from it. Federal immunity. It covers state charges and vice versa. Page 455. At the bottom, privilege against self-incrimination defined. No person can be required to make statements that can be used against him or her in a criminal proceeding. Self-incrimination. It does not apply in 3 situations. The statute of limitation, the witness has been granted immunity, the witness cannot be prosecuted due to double jeopardy. In other words, if the statute of limitation has run out, that person may have to testify against someone else. Or if the person has immunity, they may have to testify against someone else. Or if the person has already been under double jeopardy, they couldn't be convicted, then they may have to testify. So, or be convicted for contempt. Let's look at slides, actually let's look at page 456. Statute of limitation. Yeah. If the statute of limitations has run, no charges can be filed. In these circumstances, a suspect cannot refuse to talk on the grounds that it might incriminate him or her. Due to the fact that the statute can be told or stopped if a suspect flees the jurisdiction to avoid prosecution, it is possible for the statute to have run against one suspect but not the other. So let's say there's 2 people that committed a crime. One was arrested, the other one fled the country. The statute of limitation freezes when you flee the country. Then they get you back. So the person that already did the crime, or already did their time, not the crime, I guess they did both, could be required to testify against their partner. So one suspect committed a felony, or here's another situation. One person committed a felony, the other person involved got a misdemeanor charge because their role was less. When either of these situations occur, the police may be interested in obtaining a statement from the suspect for whom the statute has expired, so they can use the information against the other person, the felony person, or the person that ran. Same thing for the other situations, immunity or double jeopardy. Slide 6. Double jeopardy cannot be retried if convicted or acquitted of a crime. You can't be tried twice. Unless you appeal, the prosecution cannot appeal a not guilty verdict. Prosecutions can appeal an appellate court decision. You can't be charged with a more serious crime if you were convicted of a lesser offense. Double jeopardy does not apply if there's no verdict. So for a hung jury, there's no double jeopardy. And page 456 describes double jeopardy a little bit more, if you'd like to read that. Slide 7. Non-testimonial compulsion. The Fifth Amendment applies only to testimony. So that's only testimony. Keep that in mind. It doesn't have anything to do with the physical evidence they get off your body, which they would, meaning law enforcement, would need a warrant for. Bodily fluids, you can't refuse to provide evidence off your person. Identification features. A person's appearance is not protected. There could be Fourth Amendment issues, like if they did a blood draw or hair collection. We take your clothes, fingernail scrapings. That could be Fourth Amendment where a warrant would be required. Slide 8, non-testimonial compulsion, handwriting and voice. Handwriting exemplars. Let's say you did some fraud and forgery work and you forged a check. So handwriting exemplars are not testimonial, but the content, it's used for comparison. So, or a voice, we'll talk about live lineups in a moment. Sobriety tests. Actions and tests of results are not protected. So questions asked during the test may be inadmissible as to the content, but not the behavior. The fact that the words were slurred is admissible, but not what they said may not be. Hayes versus Florida, slide 9. Police were investigating several burglaries and rapes. A fingerprint was found at the scene of one of the crimes. The police compelled Hayes to come to the police station on threat of arrest, but lacked probable cause to actually arrest him. The police took fingerprints from Hayes, matched to the latent print, and then arrested him. The Supreme Court ruled you can't force individuals to supply fingerprints without a warrant or probable cause to arrest. So that's an issue, and I believe the end result was it was thrown out. Slide 12, Griffin versus California. Griffin was convicted of murdering Essie Mae Hodson. Griffin refused to testify. The prosecution at the closing stated, Essie Mae is dead. She can't tell you her side of the story. The defendant won't. Well, that conviction and death sentence was overturned because of that. Prosecution can't make statements at trial or during sentencing stage, making the person seem guilty because they pled the Fifth and didn't want to testify. So I think that's a huge lesson there. Slide 15, Miranda versus Arizona. This actually tells you the background of Miranda. Ernesto Miranda was arrested in Phoenix for kidnapping and rape. He confessed after 2 hours of interrogation. He signed a statement that the confession was voluntary. The Supreme Court threw out the confession. The expansion of the right against self-incrimination beyond what is simply free and voluntary created the basic Miranda rights. Page 462 of your textbook gives you the Miranda warning. Prior to custodial interrogation, so you're under arrest and the police want to interview you. Before they can, they have to advise you the following, and it doesn't have to be verbatim, but they have to make sure you understand the following. You have the right to remain silent. Anything you say can and will be used against you in the court of law. You have the right to have an attorney present during questioning. If you cannot afford an attorney, one will be appointed at no charge to assist you during questioning. That's Miranda. But you probably already heard that, but we don't want to assume. Slide 18 just talks about those exact things we just read. Now, covering any question, written or oral, a head nod is okay for I understand. Use of statement. Any previous statement given to the police can be used prior to Miranda. Page 465. Second paragraph on page 465. Custody is the equivalent of a custodial arrest. It does not include traffic stops, which are citations, and the violator is released at the scene. Brief field interviews based on reasonable suspicion are not covered. Neither does it apply to situations in which the suspect is being questioned at the police station and is not under arrest. Whether there is a custodial arrest is judged by an objective test. The subjective intent of the officer is not important. The courts use a two-step analysis to determine if the person is in custody. 1, what circumstances surrounded the investigation, and 2, would a reasonable person have felt that he or she was at liberty to terminate the questioning and leave. Next paragraph. Orozco versus Texas held that it does not matter why the suspect is in custody. Warnings are not required if a suspect was arrested for a minor crime and questioned regarding a very serious one. So it doesn't matter what the arrest is for. So Miranda has to be given if you're under arrest and it's before questions are asked. Let's look at page 466. Ooh, we can't yet.